this talk. I really thank Mohsin for accepting kind invitation. And he was traveling. He just came this morning and he's now on his fields to speak to us. We thought about this talk because of course, whatever is going on in India, particularly, and there is of course so much confusion, especially after the Supreme Court's intervention in this issue. And we just thought that why not just have a good academic discussion around this area and get more perspectives on this issue. I'll first introduce Mohsin and then maybe just speak a couple of words about the society that we have formed here at SOAS. And then of course Mohsin will speak for about 30-40 minutes, whatever time he wants to take, and then the floor will be open for discussion or whatever questions you have, and then you can just shoot at them. So Mohsin is an assistant professor at the Ginger Global Law School and runs the Center for Public Interest Law as executive director. He's currently running a legal clinic with his students on hate crimes and criminal justice system. He read law at Nalsa University of Law, Hyderabad, before completing his LLM and PhD from Yale Law School. He researches on discrimination, exclusion, law, religion, and minority rights. About the society, we are fairly very new. We started last year in December, and it was just to sort of not only feel the normative gap that we find at SOAS, that there is nothing like this society, or there is very less discussion on Ambedkar per se, but also to sort of inquire into understanding Ambedkar not only as a Dalit icon, but more like an organic thinker and a global intellectual. So we have been organizing talks. The first one was by Professor Thorat, and then we had organized a memorial lecture, which we are planning to continue next year as well as we progress. And we have a couple of more talks and some folk music events organized, lined up to be organized in coming months. So, I mean, yeah, the floor is yours. Yeah.
Thank you. Thank you so much, Asang, and all the other members of the Ambedkar Society here. And it's quite an honor to be speaking here because many of us with the law background have always considered Dr. B.R. Ambedkar as what Robert Gower would call a Juris generative figure, as a figure who has and continues to be an inspiration for constitutionalism and constitutional thinking at various different spaces. There's an institutional sort of Ambedkar. There's an Ambedkar who is quoted quite frequently by everybody, including Chief Justice Mishra and Honorable Prime Minister Modi. But there's another less institutionalized Ambedkar who is part of the struggles on the ground. And hopefully, as we move forward and more people decide to put some intellectual labor, both inside the legal field, and I'm from the legal field, so that's a bias there, and even outside, that Dr. B.R. Ambedkar will be used as a Juris generative figure. So let me start off by first locating myself in this conversation. Why? Who am I to talk about these issues? And my own experience with the question of hate violence and hate crimes, mob violence, really started around 6 to 7 months ago when some of the organizations I worked with, in a way, invited me in just to assist. The protagonists of the stories, which I'll hopefully just touch upon, obviously the people who are the grassroots level workers, activists, advocates, who are representing the victims, who are fighting for the survivors, but more importantly and most importantly, the victims and survivors themselves. And I'll try my best, to whatever extent, to sort of reflect their views on the matter. I'm not obviously speaking in any representative capacity. And most of what I'll be saying is drawn from my experiences on the field, working with many of the survivors and victims. And as a law person who's been doing research as part of the legal clinic, where we have picked up discrete case studies to understand how the criminal justice system is responding to cases of mob violence and hate crimes, but primarily from the insights of those people who are on the ground. And I think they have to be foregrounded in any conversation which we have, particularly of this nature. So what I'll try and do, in order to also leave a substantial amount of time after I speak to hopefully a very vibrant discussion, is just broadly give an outline of the debate around mob violence, mob lynching, etc., however we want to classify it, and that's an important question which I'll touch upon, and give a broad outline of this discussion. And I'll start with the vocabulary. I'll start with how should we describe what is happening, and then move on to what is happening. In some sense, give a tentative sociology of what we are calling mob violence in India, in contemporary India. Then I'll move on to discuss how the criminal justice system, how legal institutions are behaving, what is my analysis in some sense of what is happening with law. And hopefully that will ease us into the discussion around the Supreme Court decision, which, and in fact, the name of the talk, Mobocracy, is not my invention. This is what the Supreme Court says. The Supreme Court says that India is becoming Mobocracy. So what is this judgment and how should we read it? And that is an important thing. The stakes are high for how we read that judgment, because as we speak, there's a discussion around what Indian media is calling an anti-lynching law. What does an anti-lynching law mean? What should it look like? What should be the institutional shape of our battle against mob violence? And hopefully I'll end with some broad suggestions, hopefully open to a lot of questions. So when did we encounter this category of mob lynching or mob violence? So media is, and I suspect that the category of mob lynching, which is what the media is calling it, has been increasingly used only in the last 3 to 4 years. At least that's when it really came into national attention. And the reason why I decided to start with spending some time on the phraseology of it is because vocabularies really tell us how we should understand the problem. And vocabularies really then tell us how we should deal with it. And a fair amount of discussion around mob violence is really about how should we frame this discussion. What is this issue about? And when I was thinking about when did it start striking people that there is a problem of mob lynching or mob violence in India, I think there are 3 incidents which captured the national media attention. And in India, whenever somebody says national media attention, it essentially means Delhi or Bombay central English media. And some form of Delhi imperialism for you. And there are 3 incidents which in that sense captured so-called national imagination. The first, which happened in Una, where a bunch of upper caste men beat up low-caste Dalit men who were involved in cattle trading and involved in skinning of dead cattle, which has been forced occupation on Dalits for centuries. And this particular act of violence was circulated through videos, and very soon this resulted in a massive outrage across the country, primarily in the form of Dalit political activism. The second incident, I think, which was quite important was the death of this man called Akhlaq in the outskirts of Delhi, in Dadri. And the story is that a bunch of people entered into his house, claimed that he had beef or cow meat in his house, and just beat him up, beat up his son, bashed his head in with a rod, and that story also spread like wildfire. But I think more than both of them, I think, at least in my assessment, the incident which really made the issue of mob lynching / mob violence so central to how a lot of media started to discuss these issues was the death of Junaid. There's an 18-year-old boy who's traveling from Delhi, outside Delhi, Faridabad, in a train. He's with his brother, and there is some sort of fight which happens over seat arrangements. And that is a story which broadly everybody has sort of agreed. These 2 boys are sitting, there's a bunch of people get into the train, they ask him to move out, and then they start beating him up, and in that process they invoke his religious identity. They say you're a Muslim, you're Pakistani, you eat beef, and they get beaten up. And this 18-year-old boy dies on a platform bleeding publicly. And I suspect that Junaid was one of the tilting points, because to a huge extent, violence against Dalits, which is manifold, and it's outrageous to the extent to which violence against Dalits is so ingrained in Indian social fabric, that I don't think Una in itself could have been the triggering point. The reason I think Junaid really did something was, and this is informally the kind of conversations I had with people, is that with Junaid, I think people just could imagine that they could also be subject to this kind of violence. And perhaps later when we have a discussion, it'd be interesting to see why, even though there have been decades and decades of violence against Dalits, it has not led to the Supreme Court calling India a Mobocracy. And I think that there should be a moment of some amount of self-reflection. That obviously shouldn't take away from the fact that this is an important issue, or what kinds of issues really make the institutions move more than the others is important to keep thinking about. And subsequently there have been many more cases on the pretext or excuse or context of child abduction. Another famous case of Pehlu Khan, who was transporting cattle and he was beaten up and the videos were circulated. And within no time, within practically 1 year, the media was widely covering these issues. There were lots of civil society activists who were, as a whole, just be slightly cynical, and political economy of activism and legal and social activism so it started emerging around these issues. In my view, framing and context over framing has been quite important. And broadly, when I'm slightly oversimplifying, there are 3 different ways in which these incidents have been interpreted by different people. Primarily in the first phase, the framing was what I would just call violence as a reflection of human depravity. The idea was, of course, there is violence, but Indian society is violent, and these are sort of apparent, random incidents of violence. And that sort of narrative, which many political parties pushed for a long time, became more and more unsustainable when so many incidents started to emerge. So India Spend, one of the partner organizations I work with, reported that by the end of 2017, there were as many as 80 or around 80 cases of cow-related violence. And their report was that out of these incidents, 86% of the dead were Muslims. And even though one can question these statistics, but these correlations could not be easily dismissed. So that sort of framing that these are all random incidents became more and more unsustainable. But apart from that, the second narrative was that this violence is reactive violence. This violence is happening because the people on the ground are unhappy with the way cow protection laws, which I spent some time talking about, they are not being implemented well. And people are angry. And this is really happening because Pehlu Khan is a smuggler. That Akhlaq did have meat in his house. And sure, many people said, sure, violence is a bad thing. But the reason why this is happening is because this violence is reactive. And notice how this particular kind of framing places the problem or distributes the problem among the victims and the system and a whole range of other people, but tries to distribute it as further away from, let me call it, political epicenter of this violence. Again, something which I don't. But the third framing, which I support, is the framing of what I call social vulnerability. And the framing of social vulnerability claims that these incidents of mob violence or mob lynching, whatever you want to call them, are actually cases of hate violence for a variety of reasons. The first is that in most cases of mob violence, the religious and caste identity is quite central to how the violence is justified, how it's articulated, how it's conducted. So, for example, in Junaid, there were explicit statements made by the people who allegedly perpetrated this crime referring to his religious identity. Secondly, even when it's not explicitly stated, and just to clarify, the way hate crimes is ordinarily defined in the juristic literature transnationally is any crime which either partly or wholly is motivated by the identity of the victim. So in that sense, most of these incidents actually fit that technical definition. The second is that this violence cannot be understood without understanding the social as well as institutional vulnerability of the victims. So let's take the example of Pehlu Khan. This man who, with his sons and some neighbors, was transporting cattle, including cow, across the border. And borders are important because in many, many cases of transfer of cattle or transportation of cattle, people have been attacked when they are on the border. So what does the border mean? Border means an extreme form of disempowerment, particularly for socially and economically weaker people, because they do not have their community at that point of time. So I'll substantiate this. So Pehlu Khan belongs to this community called Mayo Muslims. There's a fair amount of literature on them now. And Mayos are essentially low-caste Muslims, extremely poor low-caste Muslims. And without understanding their economic and social marginalization, we will not be able to understand why somebody like Pehlu is so exposed to violence. There's a context of violence and caste and class is central to it. And that is what I call social vulnerability. And the third is the kind of messaging which these incidents of violence send out. Most of these cases of violence, whether cow-related or otherwise, are actually taken down on videos and they are circulated. What that tells us, tells us lots of things, and I'll come to some facets of it. But one of the things it does is it sends a message across the country that certain people, particularly Muslims and Dalits, are not safe. And that generates a wider sort of context of social vulnerability. And because of these three things, without appreciating them, I don't think we'll understand what is happening. And I think all these three things are what the social vulnerability frame help us to appreciate. And so what I've tried to do is to explain that the subject of violence, the people who face this violence, their condition cannot be understood without understanding social vulnerability. And who are the people who are doing this violence? What do we know about them? What does the available evidence tell us? And I think the question here really is, what is the relationship between so-called mob violence or hate violence and politics? And what I want to propose is that this relationship is not a straightforward vulgar relationship between elite political parties and what happens on the ground. There's not enough evidence to show that the Prime Minister's office is doing this or some cabinet is doing this. That is not how much of this violence is happening. But that doesn't mean there is no connection between politics and most of these incidents of mob violence. The first is what is evident studying all these different instances, and we can dig deeper in during the discussions, is that almost all these incidents are organized. And what I mean by organized is they are not whatever spontaneous things. They are not spontaneous. They just don't happen out of nowhere. So let's take the case of Akhlaq. What evidence tells us is that he was at home with his family, and there was an announcement made from the neighborhood temple. And very soon, it was revealed that many of the people who were involved in both forcing this announcement and then taking a mob inside the house belonged to different Hindu right-wing organizations, particularly Bajrang Dal. Some of them had relationships with BJP. So this is what I mean by they are organized. So they are planned at different levels. Secondly, they are also, as I just mentioned, most of these incidents are usually conducted by people who belong to identifiable Hindu right-wing organizations like Bajrang Dal and others. Third is that politics in some sense in most of these cases is writ large. So either political parties are involved during the act or they very soon get involved. And I think it tells us something important. So let's go to Jaswant Sinha's son, this minister of the central government who decided to garland these people who were out on bail after being convicted in the murder of this man called Alimuddin Ansari in Jharkhand. So there's a famous case in Ramgarh where Alimuddin was stopped, he was made to sit down right in the middle of the road, a proper video was taken, and if you see the video, it's expectedly dystopic. There are pieces of meat lying all around him, and there's practically an execution happening on the video. And these people, arguably alleged perpetrators, were convicted, 11 of them. And after their conviction by a fast-track court, and by the way, just to flag the complexity of the political relationship, the fast-track court was set up in some sense. The case was referred to a fast-track court by the Jharkhand government, which is the BJP government. And the police, and I've read the case, the police did actually a very good job of doing the investigation, and the fast-track court convicted these people. Anyway, so the High Court gave bail to some of these people, and they were garlanded by the BJP politician. So that is usually how elite party politics appears to have a connection with incidents of mob violence, which is eventually they get involved. And I reckon the reason for that is that these incidents are increasingly, or these actions of mob violence are increasingly being used by people as legitimate strategies of gaining political capital. I'll give you an example. In Mebad, a bunch of identified 2 young boys have been making videos which are being circulated among certain networks. And the videos are some sort of do-it-yourself, beat up a Dalit or a Muslim boy without killing them, but breaking their back. So these are these DIY videos which are being circulated. And the point of circulating these videos is that the people who do it are people who are politically ambitious. And that can only mean that the local, particularly BJP party infrastructure, is actually quite open to treating these actions as legitimate political actions, which allow people to use them as a strategy to enter into mainstream party politics. And this is not just one incident, this actually happens in a variety of different cases, where this is like an aspirational form of violence. Which, and by the way, aspirational politics and violence, this is something which is quite common in India, and this is just another manifestation of it. But it's quite evident that at the local level this is what is happening. And this is exactly the reason why videos of the violent incidents are so important. Why are these people taking videos and circulating them? They are taking videos and circulating them in order to generate that kind of political capital. And it works, because political parties are responding. We have ministers who go and garland it. Now let's come to the question of law enforcement and legal institutions. Is it a state of impunity? I think the evidence is yet to come in. We have been, as part of the legal clinic, we've been collecting detailed documents on every case in collaboration with some of the most reputed organizations working on these issues with survivors, etc. in Delhi. And there are almost no cases in which credible investigation has happened. There are almost no cases in which, apart from a few where we know that the police was very prompt in filing first information reports. And one of the ways in which the criminal justice system responds in these particular cases is this animal called cross FIR. So the idea in cross FIR is that the first set of FIRs, the first information reports, these are the complaints, some version of complaints which are filed in the police record, which are actionable when the police then starts to investigate, are actually filed against the victims of mob violence under the different cow slaughter, anti-cow slaughter or cow protection laws. And very soon these cross FIRs start getting used as pressure tactics against the victims. One can spend a lifetime talking about different cases in which the victims have been forced, either silenced or forced to compromise in these cross FIRs. And one of the things which I mentioned previously in Delhi when we were having this discussion is that the most dramatic part of the story is actually not what victims say and the failure of the system to recognize their voices. It is how the system actually silences the victims. It is how it becomes impossible for victims to speak up because of these cross FIRs. And therefore, the institutional context of cow slaughter laws is central to how the legal system operates. In the way the anti-cow slaughter laws operate is make law a facilitating factor in violence, a facilitating factor in justice not being delivered to the victims. The second, also these like smaller institutional facets. So for example, in places like Haryana, there are special cow cells. There are IDs which some police stations have issued to the so-called cow vigilantes or cow rakshaks, and they in one way or the other behave as official agents of the state. The question for me, and this is an ongoing curiosity, and I'll not end with a very strong conclusion on this question, is the system discriminating? Is it the case that the Indian criminal justice system is behaving in a particularly malignant fashion towards victims of hate crimes? And I suspect not really. It's not clear, but I won't come to a direct conclusion. Because many of the faults which we have identified in the way the criminal justice system is behaving are quite entrenched systemically. They are systemic in nature, poor investigation, watching up of forensics, police atrocity. These are quite systemic in the way the Indian system works. But its consequences on the victims of mob violence, because of their social vulnerability, are different. It is because of the social vulnerability of the victims that they are unable to move the system, in which in many cases they may have been able to move. But hopefully, increasingly, we'll continue doing some research and find out, is discrimination even a relevant category for us to understand how the criminal justice system works? And in many ways, and here I think I should make a link between this story and what the sort of the larger history of hate violence and anti-hate crime legislation in India is. And the paradigmatic case is the Scheduled Caste, Scheduled Tribe Atrocities Act. And our experience with the Atrocities Act is actually quite similar to what is happening in this particular case. So, to a quick sort of primer on the Atrocities Act, the atrocities, and I'll come to sort of the model of Atrocities Act in greater detail, but the primary legislation in India against crimes against Dalits and scheduled tribes is atrocities, and atrocities are defined under the Act not in terms of the affect, not typically the way hate crime legislations define crimes, which is crimes on the grounds of or crimes motivated by partly or wholly, but the model which the Atrocities Act follows is listing hundreds of different kinds of actions which are associated with, empirically we know are associated with humiliating Dalits in India. So they'll be sort of making people carry something or humiliating them in particular forms, and that is how the Atrocities Act is designed. But we can't understand the sort of the legal life of the Atrocities Act without understanding the social vulnerability of Dalits. So the conviction rates in the Atrocities Act are abysmally low because people can't push those cases. They fail to file FIRs. If they file FIRs and they are unable to fight these cases, lawyers are expensive. And of course, there's a larger systemic form of discrimination and larger social form of discrimination. And the failure to recognize the context of social vulnerability results in remarkable things. For example, what the Supreme Court recently did, where the Supreme Court in another case ruled that the Atrocities Act is being consistently misused. And in order to show that, in order to evince that, the court said, just look at the conviction rate. The conviction rate is so low, which can just mean that people are misusing it. And the reason, as we can imagine, the reason why the court was unable to grasp the irony that the reason why the conviction rates are low is not because people misuse it, but because they suffer from social vulnerability. And they use precisely the evidence which should have allowed them to strengthen these laws, if at all, to actually weaken them. And that is exactly the problem for courts when they miss out the question of social vulnerability. Alright, now I don't know how long.
We have time.
Great. So there are two more things I wanted to talk about now. So moving from a terrible decision of the Supreme Court, which now the news tells us is being reversed. What the court did was, quickly to tell you what the court in that case on Atrocities Act did, was that it sort of weakened the Act, particularly official accountability under the Act, and said that this Act is being misused and now that it's being reversed. But sort of the attitude, it appears, of the Supreme Court towards mob violence appears to be slightly different. Because the Supreme Court 2 weeks ago, I think it's a 17th July judgment, on the face of it gives a very strong judgment against mob violence. The story of the litigation is sort of a bit conflicted because not everybody working on the issue of mob violence against primarily religious minorities and others wanted to go to the Supreme Court or decided to go to the Supreme Court. But there were a few lawyers who did eventually go to the Supreme Court, and speaking as a participant from a distance, I don't think many of us are very optimistic that the Supreme Court will deliver a judgment which will be useful for the victims and the survivors. But the Indian Supreme Court does have a great gift of surprising people, both pleasantly and more often than not otherwise. And this particular case, in my view at least, was a pleasant surprise. What the court did was that first it recognized that this is a problem. It had massive chunks of the judgment. Chief Justice Mishra wrote that there is a problem, India shouldn't turn into a mobocracy, we should care about tolerance or good things, and ended up with giving detailed guidelines on how the police, primarily the police, should behave. And there are 3 or 4 different elements which we can discuss in greater detail later, which the judgment talks about in its guidelines. So the Supreme Court offered guidelines to the police and to the state. The first set of guidelines, first important element of the guideline was providing a standard operating procedure for the police. that they should file FIRs in time, charge sheets in time, which they should do in any case. They should have a nodal officer to make sure that these things don't happen, that they should have intelligence and investigation. The second important element in these guidelines is what I call command responsibility in this context, which is that not only will a certain police officer who has failed to follow his or her duties face departmental inquiries, but their superiors would also be held accountable. And this is a model which was tried in the Communal Violence Act bill, which didn't eventually become an act. It is also attempted in different kinds of hate crime legislations in India, and that's an important thing. And the court also talked about compensation for victims. It also talked about protection for witnesses. So there are a range of good things which are there in the judgment. But and one way to read this judgment is strategic, and that is important because now the court also asked the government to frame an anti-lynching or anti-mob violence law, and how that law will be framed will depend quite importantly on how the judgment is read, because that is the mandate in some sense which the court has given to the government, which itself for sort of people who are interested in inter-institutional relations, it's a strange situation where the court is telling the parliament what to do, but again, that's a longer discussion and I'm happy to sort of have that discussion as well. But in any case, in my view, the way the judgment is read is exactly how the law will be made, and therefore one way to do it is a strategic reading. And I guess perhaps that's the only way it should be read. But I promise Hassan that I'll try and also give competing readings of the judgment. Perhaps one less flattering reading of the judgment is how the judgment itself frames the problem. How does the court see the issue with mob violence is? And one of the most important strains in the judgment, if you go over it, is the judgment reflects a certain amount of state centricity in its evaluation of the problem. So mob lynching or mob violence becomes a problem of rule of law. It becomes a problem because it disputes or rejects the state's monopoly over violence. And that is one of the running themes in the order. The court calls these mobs are taking law into their hands. These mobs are essentially behaving as vigilantes. And treating the problem of mob violence as a problem of vigilantism really argues, or implicitly it assumes that the problem of mob violence is a problem of the failure of the state to maintain monopoly over violence. And that, in my view, is an of course, nobody can dispute that, at least let me not dispute it right now, that state's failure of maintaining monopoly over violence is a problem. Sure, for a court of law, it is a problem. But it is definitely a crisis for the judgment, and crisis for our reading of the judgment if that is an exclusive reading of the judgment. The reason is because an equally important perspective, an equally important interpretation of the judgment is what I call a victim-centric interpretation of the judgment, which essentially means that victims, the harm which mob violence causes is also on the dignity and vulnerability, of the victims, and among the humiliation which is caused to the victims. And this goes back to the framing which I proposed right at the beginning, which is the framing of social vulnerability. Can we read this judgment also in the frame of social vulnerability? And I propose that we can, and we definitely should. The reason is because if we do not do that, then the legislative process which is going to follow will also leave out the question of social vulnerability altogether. It will primarily become a problem of law and order. And if it becomes a problem of law and order, then no legislation which follows the Supreme Court judgment will deal with the question, dealing with the problem of social vulnerability, compensation, protection of witnesses, larger systemic change, particularly institutional infrastructure like cow protection laws. And this is exactly how the still dispersed discussion around the legislation is operating. There are one set of actors who are arguing that the law should be made against lynching.